Welcome, everyone. Good late afternoon, good early evening, good afternoon, good morning to those of you joining us around the world. Welcome to this very special event, the book launch for Towering Judges, a comparative study of constitutional judges, a volume edited by Rehan Abeyratne, Assistant Professor of Law here at CUHK Law, and Iddo Porat, Associate Professor at the College of Law and Business in Israel. By way of brief summary, Towering Judges explores the work of 19 judges from 14 jurisdictions, each of whom stood out among their fellow judges and had a unique impact on the trajectory of international law, of constitutional law rather. Among other themes, the book explores questions such as what makes a towering judge? What are the background conditions that foster or deter the rise of towering judges? Are towering judges on balance positive or detrimental for constitutional systems? How do towering judges differ from one jurisdiction to another? How do political and historical developments relate to this phenomenon? And how does all of this fit within global constitutionalism? We are very privileged to be joined today by several participants in this project who will speak relative to some of those themes and the chapters they authored in the book, as well as the collective research project as a whole. Their contributions to both scholarship and service are so extensive that if I were to list them all for you now, I could easily take all of our time here tonight. I will instead, therefore, be exceedingly brief so as to maximize the time and the opportunity you have to hear from all of these scholars rather than from me, as well as the time we have for questions and answers at the end. First, you will hear from the editors, Rehan Abeyratne and Iddo Porat. Then we will have the opportunity to hear from several leading scholars in the field of comparative constitutional law, including true luminaries in the field. First, Professor Rosalind Dixon, Professor of Law at the University of New South Wales. Professor Andrew Lynch, Professor of Law and Acting Dean at the University of New South Wales. Professor Alon Harel, Professor of Law at the Hebrew University of Jerusalem. Professor Malagodi, Assistant Professor here at CUHK Law, and Professor Ngoc Son Bui, also Assistant Professor here at CUHK Law. Each of the speakers will speak for about 10 minutes. I will send them a reminder when they have about 1 minute left, and I trust they will heed that reminder, or else they will find out I am not, in fact, a very effective keeper of time. A procedural note for all of you members of the audience. If you have any questions during the course of today's presentations, please send them in to me using the chat feature on Zoom. My name is Christopher Roberts. You can find me in the participants lists. I'm also an assistant professor here at CUHK Law. I will then read those questions out during the question and answer session. One thing that typically occurs is that everybody waits until the end of the presentations to send in their questions. If you do want to get your question in, I encourage you to send it to me early. That way you will get to the front of the queue and you will be sure it will be posed. Let me note for everyone's information as well, this event will be recorded and posted on the center's website. So if you want to watch it or share the link with colleagues, it will be available in short order after the event there as well. Finally, let me note we are privileged to be joined tonight by one of the towering judges in question, the Honorable Kalyan Shrestha, the former Chief Justice of the Supreme Court of Nepal. Justice Shrestha the warmest of welcomes to you. Without further ado then, let me hand over the floor to the editors, Professors Abeyratne and Porat, please.
Thank you very much, Chris, for that introduction. Let me join you in thanking everyone for attending, the audience, the contributors to our book. Let me also echo you in thanking the Honorable Kalyan Shresthaji for joining. Thank you very much. And I just want to add a couple more thanks. First, I see my former dean in attendance, Chris Gain. Thanks very much for being here, Chris. And thank you for your support of this project at the outset 2 years ago when we held a conference at CUHK Law. And I have one other note of thanks, but let me share my screen first. And that note of thanks is to my colleague, Mara Malagodi, for suggesting this cover design of the baobab trees. I think it's come out really nicely. And I know Iddo and I are both grateful to you, Mara, for that. So thank you. So I just want to say a couple of brief things about the book. It's out this week, and I hope those of you in attendance will consider purchasing it. A couple of sort of initial things before we hand over, I think, to the contributors to say a little more about the individual judges and some of the themes that arise from the book. The first is sort of what we were trying to do. So, most scholarship, I would say, in the field of comparative constitutional law tends to fall into one or of the following two categories, right? So there's a lot of scholarship on kind of legal or jurisprudential developments, legal transplants, the migration of constitutional ideas like proportionality. And there's also a lot of scholarship on institutions, right? The role of constitutional courts, how constitutions are amended, etc. And our aim, I think at core, was to try to push the field in a new direction by considering the role of judges as drivers of constitutional change. We believe there's a distinct phenomenon, particularly over the past 30 or 40 years, in which individual judges have significantly affected the trajectory and development of constitutionalism in their jurisdictions. The book, despite the title Towering Judges, is not intended to be hagiographical, right? This is not sort of an exercise in celebrating particular judges, nor is it seeking to advocate for more judicial activism or sort of the rise of more towering judges. Rather, what we aim to do is to show how across different contexts and constitutional systems, towering judges have emerged, the ways in which they've made an impact, and we also seek to assess their legacies. So what makes a towering judge, right? At some level, I think we can all intuit a towering judge or towering judges from our own legal systems. I have a picture here of Chief Justice Marshall, perhaps the quintessential towering judge in the US context, but by no means the only towering judge in the US context. But sort of aside from this kind of it when you see it test of what a towering judge is, I think Iddo and I wanted to spell out a little bit more clearly what we mean. So the first thing we had to do was come up with a good term. We thought about heroic judges, super judges, variations on both of those, but we decided that those sorts of names were a little too positive, right? A little too kind of normatively weighted. And so we ended up on the term towering. And by towering, we mean a judge that is significantly taller, metaphorically speaking, right? Significantly taller in terms of impact than his or her peers, right? So towering is a relative concept. It's a contextual idea, right? The nature of a judge's impact depends on the political and institutional framework within which they operate. And as I've hinted already, it's not necessarily a positive descriptor, right? It's a measure of impact. That impact can be positive, negative, or mixed. And in fact, most of the judges that we discuss in the book have complex mixed legacies. The one other thing I'll say about case selection is that we limited it in a couple of ways. So to have some degree of temporal and topical consistency, we only considered judges from the 20th and 21st centuries, and we focused on judges whose main impact was in constitutional law. So great jurists of private law, think someone like Lord Mansfield, great constitutional judges from hundreds of years ago, think Chief Justice Marshall. These sorts of figures are not included in this book. So without further ado, here are the judges that we actually selected. In the interest of time, I'm not going to go through each of them in any detail. Some of the contributors are here today, and they will tell you about the judges that they wrote about. But I just want to say a few general things. The first is that we tried to get a wide geographic selection of judges. So we have judges from all the inhabited continents. We tried to get judges from all the major legal systems. And so we have judges from common law systems, from civil law systems, and we even have one judge, Judge Bin from Vietnam, a judge from a socialist system. Of course, this is necessarily a subjective and incomplete list. For every judge, perhaps, that we mention, somebody could plausibly mention a different judge from the same jurisdiction who may have an equal or better claim of being a towering judge. But we're happy with this selection, and we think the authors justify each choice very effectively. There's also a big gender imbalance that must be mentioned. There's only one female judge in our list, and this is something we can talk about in a little bit. We talk about it in our introduction to the book, and Ros Dixon talks about it in her chapter, and I'm sure she will mention it in her remarks shortly. So a little bit about how judges tower, right? We can think of this as dimensions of toweringness. There's three dimensions that we focus on, right? These are not mutually exclusive. So most of the judges that we selected have a significant impact in more than one of these areas. So again, very briefly, without going into too much detail, the three dimensions are political, institutional, and jurisprudential. So by political, we mean judges who either intentionally or not promote a particular ideological, moral, or political agenda. Right? Some of these judges, like President Aaron Barak of the Israel Supreme Court, are tied to kind of liberal, rights-protecting, or globalist agendas, right? And Alon Harel will talk about him shortly. There are also judges who are political in a more literal sense, right? So Sergio Verdugo, who unfortunately couldn't make it today, wrote about Judge Valenzuela in Chile, who was influential in ousting the Pinochet regime there. In terms of institutional toweringness, here we mean judges who leave a lasting legacy in terms of the legal institutions they create, enhance, or protect. So some of our judges helped establish or solidify their court following a political transition. Chief Justice Shrestha in Nepal, I think, is a good example of this, and Malagodi will discuss him shortly. Other judges helped protect a court from outside pressures. Justice Cepeda in Colombia, who David Landau writes about, I think fits into that mold. And then finally, we have jurisprudential towering judges, right? I think this will be most familiar, at least to the lawyers or law students in the audience. So these are judges who may leave an intellectual mark on the court that they serve on and its case law. And I should be clear here that by jurisprudential, we don't just mean judges who wrote a lot of opinions or wrote really high quality opinions, though we do include such judges, but we also include judges who were collegial, who were able to marshal their colleagues to move the law significantly in a particular direction. A good example of this is Sir Anthony Mason in Australia, and Andrew Lynch will talk about him shortly. Final thing from me, why do we have towering judges? What are the conditions that are conducive for them? We talk a lot in our introduction to the book about historical context, and Iddo, in fact, has a chapter about it, so I'll leave that to him. But I'll briefly mention briefly go over the other three things. So first, institutional conditions. One of the things you might have noticed from my list of judges a couple of slides ago is that there are no judges from continental Western Europe. So why is that? Right? And one of the reasons we think that is because of institutional conditions. Right? Constitutional courts in Europe tend to have limited terms for judges on their constitutional courts, right? Spanning from 3 to 12 years. Right? Having a limited term significantly constrains a judge's ability to have long-term effects or to build a kind of towering reputation. Common law judges, on the other hand, typically have unlimited terms, right? Terminated only by a fixed retirement age, or in some cases, like the US, they have life tenure. There are other institutional conditions that we mentioned, right? The sort of practice of writing signed opinions versus unsigned opinions, the ways in which judges sit in panels, etc. There are also cultural conditions, right? So certain constitutional cultures are more formal and anti-individualistic. Germany, for instance, and this may prevent the rise of towering judges. Other cultural settings tend to be more favorable for individual judicial personalities to shine through. I think India is a very good example of this. And Justice Bhagwati, who I write about in the book, I think fits that model. And then finally, timing. Some settings, right, just seem to call for towering judges. I think a good example here is Chief Justice Chaskelsen, the first Chief Justice of the South African Constitutional Court post-apartheid. He was handpicked by President Nelson Mandela for the role, and this put him in a good position to be a towering judge. So those are just some broad thoughts from me. Let me thank everyone again for attending, and I look forward to the discussion. Let me now hand over to my co-editor, Iddo Porat.
So thank you, Rehan. Thank you, everyone, for being here. Thank you for the contributors that are here. Thank you to Judge Shrestha. And thank you, Rehan, and the Chinese University of Hong Kong for setting this up. This is really great. And it's really great to see this book coming to life very soon in print. And the intellectual journey that we started a couple of years ago in a time that seemed really like ages ago. It's a couple of years BC, that is before Corona, now coming to fruition. So that's really exciting. In my short, really brief presentation, I want to focus on one particular aspect of towering judges. And I'll put the slide on to give you the title of this. Here we go. Right. So the towering judge is a revolutionary judge. Right. This is the title that I'd like to talk about. And this is something that I touched on in my chapter for the book. And I guess the more full title would be "The Towering Judge is a Revolutionary Judge in the Age of Global Constitutionalism." Right. And I'd like to emphasize at the beginning that this does not relate to all of the judges, and definitely not to all of the aspects. Really, there's a multitude of aspects that Rehan talked about, many of which now, and this touches on some of them, but I think it's an important aspect and something that makes this particular maybe collections somewhat typical, or it's typical for this particular collection. Okay, so why revolutionary judge? And I'll talk a bit about a revolutionary judge, and then talk about the age of global constitutionalism. So the idea of a judge as a revolutionary figure is really not a straightforward one, and it's antithetical to much of what we may think, or to a set of ideas and value that we associate with judges. Right? So judges, in these under one conceptions, are to apply pre-existing law to the litigants in front of them. They are objective, they're neutral, they are their only authority is the law. Maybe their only purpose is to apply the law justly to the litigants. They are under the rule of law, which is a rule of pre-existing set of rules. And revolution doesn't exactly sit with this particular conception of a judge. They're also not elected, most of them. Some of them are elected, but all of those that are elected in ways that are different than the regular election of representative bodies in democracy. And they're all independent, and in that sense, they're not they're not supposed to give us account. They're not accountable to the political forces in society. And yet, some of them are self-consciously revolutionary in their jurisprudence. And I'll give an example in two citations of two judges in our collection. I think that typifies this towering judge as a revolutionary judge most distinctly. So here's the first one by from a judgment from Judge Laszlo Solyom from Hungary, which is in our book. The court must fulfill its task embedded in history. The court is the repository of the paradox of revolution under the rule of law. So we have here a historic task given to the court and a revolutionary task, right? Still a revolution under the rule of law, but revolutionary nevertheless. And look here from Judge Aharon Barak from a speech he gave in 1977. As judges, we are not limited to interpreting and operating the existing laws. We are the spear edge of the aspiration to a more desirable and better law. We are the architects of social change. We have the abilities to build a better and more just legal system. We do not see our role as limited to legal technocracy, but we perceive our role to include legal statesmanship, right? So we have here architects, social change, we have statesmanship, right? Very different from the other model of a judge that I talked about. Now, the claim that I want to make and that I make in the chapter is that this particular revolutionary idea of a judge, which again doesn't, maybe these are the more extreme cases of such a judge, but some of the other judges also touch on it to different degrees. So to explain it, we need to understand these particular towering judges as operating in a particular context, a context in time and a global context, right? And that time is roughly from the 1980s through the 2000s, late 2000s, which most of our judges operating in the book operate in those years. And the context, the global context is a context we can call global constitutionalism. And for the couple of minutes that I have left, I'll just say a bit about this context and why it makes judges or makes the idea of a revolutionary judge fit the role of a judge. So global constitutionalism is a set of ideas that went into motion after World War II, particularly in Europe, is epitomized by the EU, the European Court of Justice, European Court of Human Rights, other transnational international bodies and constitutional courts, and is set around the idea of cosmopolitanism, liberalism, universal human rights. And around the 1990s, we have the idea that this is a culmination of these set of ideas, and this culmination comes when the Soviet blocs falls down and several other authoritarian regimes, South Africa and Latin America, fall down. And here is the last quote that I'll have, and this is from a seminar that talks about this age. These is from Owen Fisk from the University of the Global Constitutional Seminar, and these are words in 2016. The seminar was a project of its time, a triumphant moment in the history of democratic constitutionalism viewed on a world scale. It might be seen as a tribute to the triumph of democratic constitutionalism in so many parts of the world in the 1990s. The aim is to create a forum for those judges engaged in the practice of democratic constitutionalism to learn from one another. We assume that by sharing their knowledge and experience, the values then being applauded, the values of liberal democracy, constitutionalism, and cosmopolitans, would be deepened and extended. So towering judges in this particular context view their role as part of this change. And this role is not viewed as partisan or political. It is viewed as objective, and it is viewed as part of democracy, but they have a crucial and active role in which they are collaborative around the world to effectuate that particular set of ideas in their own societies. And they can be part and even spearhead this particular change and revolutionary change within society at this particular age. Okay, so I'll stop here just as, and this is just a way of putting in context some of the more distinct or extreme version of towering judges that we can see around and put them in historical context. So thank you, and I'm really looking forward to hear all of you.
Okay, thank you so much to our two editors for providing some context there relative to the project as a whole, bringing out a lot of the common themes and sort of the frameworks of analysis deployed. Let me turn over the floor now to Professor Dixon to discuss her contribution and thoughts relative to the project. Please, Professor Dixon.
Thank you, Christopher. Thank you very much for the opportunity, and to CUHK for hosting us. This is a book launch, so I want to congratulate the editors, Iddo and Rehan, for what is a terrific volume and opportunity for all of us to have come together and reflected on jurisdictions that we're familiar with, and a really interesting and fruitful joint conversation. Son is not only an author in this context, but helped organise this evening. So thank you, Son, for taking the lead in encouraging it. And of course, Rehan, to your former Dean, as well as the Chief Justice of Nepal, for joining us. So it's my pleasure to be part of this celebration of what is a really important book. In some ways, my chapter has a somewhat anti-celebratory feel. It has a somewhat critical take on the project as a whole. And it is a credit to Iddo and Rehan that they've let me loose on their celebration to bring my somewhat more tempering perspective to bear. So let me say what I think is deeply important about the project, then an observation about what I think, in addition to the very important insights their introduction offers, my chapter might add to our analysis of who becomes a towering judge and why, and then talk about what I think the danger of the project is. So why it's wonderful is that it's an opportunity, as Rehan said at the outset, to delve comparatively into institutional detail at the level of who judges are, institutional leadership, and the interaction effects among individuals on courts. And I think as comparative constitutional studies becomes a deeper and richer field, it's really valuable to have accounts that go really deep into the sociology of institutions and understand the personal, philosophical, psychological, and contextual factors that drive overall legal political dynamics. And I think each of the chapters does a marvelous job of that. And you know, it's very readable, it's very interesting, and it frankly is a great contribution to understanding comparative constitutional experience at that granular level that I think is where the field is going and needs to go. So I think it's an enormously valuable contribution in that sense. And, you know, my colleague, Andrew Lynch, our Dean, and Gabrielle Appleby have done a chapter on the Mason Court, which I know well. And I think it's just a perfect testament of how rich the volume is, that if you know the jurisprudence really well, you still get something really important and rich out of reading the account framed through the lens of a towering judge framework. So I think it's a wonderful and important book that we will all be reading and debating for many years, and that its methodological contribution in the field is to turn our attention toward this more granular institutional account. Like Iddo and Rehan, I think there are a number of factors we can say about what predicts who will be a towering judge. But I want to draw out one important factor that certainly came up in our conversation in Hong Kong just over 2 years ago, and which I note in my chapter, which is whether you're a towering judge is a mix of objective and, if you like, subjective or recognition-based factors. So whether you're a towering judge is a product of whether you're a really important and skilled and influential judge within your jurisdiction, but also recognized as such. That to be towering is not just to be tall, but to be seen as tall by others. And I think that that is in Iddo's chapter important to note that it is both domestic and cosmopolitan recognition that can drive that form of towering status. Some judges are going to be towering in both contexts. So Barak is the classic example, towering within Israel and towering on a cosmopolitan plane. But other judges will have a differential reputation. So for instance, in Australia, someone like Sir Anthony Mason, who Gabrielle and Andrew write about, is no question towering, whereas Michael Kirby has a strong following but a lesser reputation, whereas internationally Kirby tends to have the larger reputation, other than in Hong Kong, where Sir Anthony obviously looms large over the basic law and its interpretation by the Hong Kong Final Court of Appeal. So I do think it's important to recognise that recognition is a part of what makes one towering, and that it is both domestic and cosmopolitan in interesting ways. And in ways that ultimately make this project not just a study of towering judges, but a work that is actively contributing to who a towering judge is. So it is endogenous to whether Iddo and Rehan selected you as to whether you will be regarded as towering in the future. Because towering is a recognition practice as much as a fact, and the judges that you selected are therefore getting a strong nudge in terms of history toward being seen on the cosmopolitan plane as towering. Now, they're all plausible candidates for inclusion, but you have exercised a certain kind of editorial power that is not just the power of editors, but the power of, if you like, towering judge making as well as recognition. That goes then to some of the challenges of figuring out who a towering judge is and what is likely to make for such a judge. Clearly, a person of outstanding intellect is likely to be predisposed to be a towering judge. As Rehan said, when they're in office, both were there crises, were there particular jurisprudential needs and changes, and how long were they there? It's very hard to be towering if you're there for a very short time. So were you there for a long time at a particularly historically significant time, and who were you there with? Which is, you can be an incredibly talented jurisprudential and institutional leader. If you are surrounded by people who never agree with you, well, then you're going to be, in Andrew's book, the great dissenter, not the towering judge. Towering judges are not intellectual giants who stand in the wilderness in dissent. They are people who at a particular moment have moved at least some of their colleagues with them. And that is a product of both the person and the time, in the sense of who they were on the court with. I do think, however, that if you take Rehan and Iddo's point seriously, and I love, Mala, the image you suggested to them of the trees, that there's an element of, if you like, relative dominance on a court, then certain institutional roles predispose one to that status, and the role of Chief Justice or Court President is one of them. And in my chapter, you will note that there is a table that sets out the quite high percentage of judges that Rehan and Iddo selected for inclusion in the volume that are in fact Court Presidents or Chief Justices. And so it's interesting to think about, in particular, those judges included who were not Chief Justices or Presidents, and how it is and why it is that they came to exercise that similarly towering status or role. But the most problematic predictor of towering status is gender, and the fact that only one of the list of judges included in the volume is female identifying. Now, that is partly misfortune on the editor's part, because they had a list of somewhat other judges who were candidates who weren't ultimately editorially included, but through no fault of the editors. But I want to suggest that there might be something about the concept of the towering judge that is in itself gendered, in the following sense. If we take a towering judge to be a leading judge who is dominant, there might be two reasons for thinking that, at least historically, male judges are more likely to be towering in the relevant sense. First, women may well be willing to exercise significant institutional power, indeed leadership, but find it difficult either because they are not socialized to want to do it, or because they are socialized to expect backlash and repercussions if they exercise that leadership in a dominant fashion. So women may find that they are willing to step up all the way to equality, but to step up to a place where they are perceived as dominant is either something that is uncomfortable or one that they're perfectly happy to do, but which they expect to attract negative responses from colleagues. So that dominance as an institutional position is one that women are socialized to expect to be uncomfortable or unattractive, and therefore that they are less likely to step up to assume that role. That second, even if they do assume it, they are less likely to be perceived as dominant. And this goes back to where I started, that being towering is a socially constructed status that depends on not only leadership and institutional leadership, but recognition of that leadership. And often the most effective people will have implicit influence and leadership. I note in my chapter that sometimes the mere citation to a judge doesn't tell us that they have been influential, that sometimes the judges who are most influential are least cited for the things that they are most influential about, that they may have garnered institutional change, a majority for a particular position, shifted a judge's view on something in ways that we'll never know about. And that the recognition of women as dominant may be less likely to occur in a world of implicit bias. I cite a really interesting study from the social sciences about gender and, if you like, dominance. It's the finding that people can be very comfortable with equality, but start finding it much more discomforting when women start to occupy a position of dominance. And the study comes from a wide range of interviews and lab-based experiments involving earnings and male and female equality versus dominance, if you like, in female earnings. That there may be something deeply rooted and unconscious about a resistance to female leadership that is perceived as dominant. The more benign explanation, of course, is that to date, women have not been Chief Justices. As I said before, most of your towering judges are Chief Justices or Court Presidents, and as we see over time, more women become court presidents and Chief Justices, one would see a natural increase in the number of women recognised as dominant in the relevant sense. But it may be that the absence of female judges isn't just an editorial blip. It is a sign that the concept and the category itself is a problem, and that the better conception is leading judge, not towering judge. And that to understand effective judging is to see judges as embedded in a collegial context, as exercising political and jurisprudential leadership in a way that is embedded in courts as a they, not an it. That if you want to be a rock star, go and be a rock star. But if you want to be a judge, you're a part of a collective institution. And that the most effective judges are those who are intellectually giant, but institutionally collegial. And so my biggest worry is that rather than the absence of women being the problem itself, that it is the miner's canary that tells us that the category itself is problematic, and that we should be, insofar as we are celebrating rather than noting, and Rehan had that very clever disclaimer at the beginning, which is not celebration, we should be celebrating leading collegial judges and not towering individualistic judges. Both because towering individualistic judges are more likely to be Chief Justice and male identifying, but also because they may miss out on the benefits of collegial deliberation, learning from each other, producing better judgments, and frankly, ensuring institutional continuity. If one wants to press on a sore spot in Israeli debates, one contention would be that Barak shone too bright as an individual judge in terms of the court's long-term institutional legacy, and that unlike someone like President Chaskelsen, who acted in a highly collegiate fashion so that when he was no longer on the court still had the same institutional respect and institutional memory, the Supreme Court of Israel was more vulnerable to political attack after Barak stepped down, in part because he was too towering relative to his colleagues, and that there actually are numerous judges in this volume who are much closer to the ideal of the collegial judge, the leading collegial judge, than the towering judge. And so one of the things that I think is wonderful about this project is it's the beginning, not an end, to a new form of institutionally focused comparative constitutional studies. But my prediction, if you want it, is that when we've done all the work following up on the agenda that Rehan and Iddo have set out, the votes will be in for the leading collegial judge, not the towering judge, as the normative ideal, and that many of the chapters could actually be cut and paste with a new title into that new volume without too much violence to the analysis of what made those judges influential and admirable and significant within their own jurisdictions. We might get a few new judges, however, with different attributes, including more women, if we were to do that. So my hope is that others will continue. I certainly hope to contribute to what I regard as a new and fruitful agenda, but I do think we need to be very cautious as we engage and celebrate this wonderful book about not valorizing overly the concept of the towering judge.
Great. Many thanks, Professor Dixon, for that fantastic set of insights, challenges, and interrogations of the concept of towering judges as such, as well as, of course, pointing the way towards the way that this sort of field of research might continue to evolve in future. Let me hand over the floor then to Professor Lynch for his presentation. Please.
Thanks very much. And I also want to begin by saying what a pleasure it is to be involved, not just in the book and the preceding workshop, but this event, and congratulate Rehan and Iddo on the publication. The comments of both of them and also my colleague Ros Dixon just then have just reminded me what a fantastic time we had in Hong Kong, what an exciting discussion it was over 2 days. I've never thought so much about the word towering and everything that it is packed into it, and what it might be used to refer to in describing individuals of any kind, let alone judges. And already I can recall those discussions and remember why this is such a great achievement, and how much I'm looking forward to holding the book and reading all of that material again. I also want to acknowledge my co-author, Professor Gabrielle Appleby, who's unable to be here tonight, and send her very best wishes also. As has been, as is clear from the agenda and has been talked about, our choice for a towering judge from Australia was Sir Anthony Mason, who was Chief Justice of the High Court of Australia. But our chapter actually reveals a real duality to that, in that we considered Mason alongside the alternative choice that we might have made, and which undoubtedly others would have made, which was the figure of Sir Owen Dixon, who was really a dominant force on the High Court of Australia for the mid-20th century. He left as Chief Justice in 1964, and Sir Anthony Mason began his tenure just 8 years later. So they didn't serve alongside each other, but those two figures really bestride the court of the 20th century. And really, I suppose, when I was listening to Rehan talking about the themes of the book, it reminded me again around the agonising we had on that choice and the significance, which I'm sure will come up in discussion of those themes relating particularly to timing. Each of those judges was such a significant figure of their particular generation or age. And I do think that those broader themes that come out of the book from the individual stories are part of what makes the whole topic just so fascinating. And to repeat what Ros has said, I mean, as a piece of comparative constitutional law scholarship, it works on two particular levels. There's the individual judicial studies, and I think that, to use her expression, the granular approach that you get from that. I mean, I've not found a more engaging way, really, of learning so much about so many jurisdictions as we did in such a very compressed conference. But at the same time, then, to really build a much deeper understanding of conceptions of judicial leadership, reputation, and greatness or toweringness. So the book succeeds for me, and everyone who I think has been involved in reading and just talking about the papers on those two very distinct levels. Enough on those general observations. Who is Sir Anthony Mason and why did we select him? Well, we really focused on two aspects of leadership and drew on the work of Richard Corns when he had written an earlier piece on the New Zealand Supreme Court. And so we talked, and we talk in our chapter, I should say, on Mason's jurisprudential leadership and legacy, and also his personal qualities and his relational leadership. And collegiality is one aspect of that I'll talk about, but also his willingness to engage the community at large in the topic of the High Court. So turning to Mason's jurisprudential legacy, we emphasise three particular things. Firstly, he challenged the orthodoxy, the emphatic orthodoxy of legalism in Australia's constitutional culture. Which even as a rhetorical device, if not conceding a more substantial operation for legalism, sustained a muted or minimal sense of the judicial role in Australia's constitutional system. Mason introduced what we refer to in the chapter as an inflection towards a realist method of judging. He wasn't the only judge to do so, but his shift in that proved, I think, more influential than others who had preceded him and those who sat alongside him. On the back of that, the second thing we highlighted was that Mason defended the capacity of the judiciary to protect rights in ways that, on occasion, might surpass the capability of the political process, particularly the powers of the legislature to effect meaningful change. And thirdly, Mason's candour regarding the role of realism in judicial method prompted him to articulate values that endure as constitutional touchstones to this day. And in particular, his approach to popular sovereignty as a basis for the Australian Constitution following the legal independence from the UK that was achieved by the Australia Acts of 1986, the year before he became Chief Justice. Not only supplied a new and more palatable, politically palatable grunge norm, but paved the way for landmark decisions on rights, both civil and political for the Australian community generally, but also property rights for Indigenous Australians that proved transformative national moments. Well, so far so good. Those are the jurisprudential keynotes that we aim for in the book. But we also wanted to consider Mason relative to his colleagues and to his opportunities. He came to the court, as I think I said, in 1972, but really it was his elevation as Chief Justice that signalled a new era for him and for the High Court, and one that had connections with a strongly emerging sense of nationhood at that time for Australia in a globalised world. That related to his judicial leadership in two particular ways. The first I've touched on, which was the significance of the Australia Acts as achieving legal independence for the country and the court's consideration of what that might mean both as a legal question, but also for the role of the institution itself relative to the political arms. And the second was the failure of political mechanisms of constitutional reform over the 1980s under a progressive left-leaning government that bore no fruit and seemed really to bear out Mason's justification of the judicial role and its capability and responsiveness relative to that of Parliament. We need also to acknowledge the Mason Court as an institution, and the label, or that appellation of Mason Court, is something that isn't as equally applicable to the high courts of different Chief Justices. And this is something that's explored really in a book that Ros and another colleague of ours, George Williams, wrote on the High Court and Australian politics, which is organised thematically around Chief Justices. To speak of the Mason Court, as someone once said, is a much more meaningful thing than to speak of the courts of other Chief Justices as cohesive and distinctive eras or identities. The Mason Court was a uniquely balanced and effective collection of judicial individuals, able to come together to resolve long-standing problems in Australian law with a single voice on occasion, but also to diverge in really intellectually stimulating and satisfying ways that fostered both innovation and legitimacy in equal measure. Mason himself was the centrepiece around which the other judges were frequently arranged. His personal rate of dissent was far lower than that of any other member of his court. The other 6 judges were as likely to find themselves in agreement with their chief or in a minority. And lastly, in our chapter, we highlight Mason's work beyond the court, his public defence of its work through engagement with the media in ways that hadn't been seen until that time, and also his deep engagement with academia. The latter continued really for the quarter of a century that followed Mason's retirement, having reached the mandatory retirement age of 70 from the court. And that has, we think, and we'll touch on this in the chapter, contributed really to the ongoing relevance and engagement of the following generation with his jurisprudential legacy. A final thought, really, just to speak again more broadly about the book, is that I think we, along with all other authors, were very wary of this being an exercise in hagiography. And so we have in the chapter noted aspects of Mason's career that have disappointed some people, but also been seized upon by his detractors. And a significant aspect of that concerns advice that he gave to the Governor-General at the time of the Whitlam government's dismissal, which is a constitutional crisis of great magnitude in Australia, dated in 1975. Mason's involvement has only, this last decade really come to true light and understanding. But aside from those features that we do touch on, I would imagine most readers of our chapter will view it as essentially one of effusive praise for Mason. And if that's a criticism, I think it's one that Gabrielle and I will wear quite contentedly. I liked Rehan's opening comments, and it is conceivable that a towering judicial career could be quite contrary to that of Mason's and could look quite different. But I didn't think that was the Australian story as we discerned it. And when we think about towering, and I think about what Iddo said around revolutionary judges, the word for us suggested an impact and a presence that is related to change. And it is change that lasts in some way, if only in that the court and its world looks different after that individual, and from that point on evermore. And in that sense, we certainly viewed Mason as a towering judge. Thank you.
Many thanks, Professor Lynch, for those fantastic insights. I now then pass the floor to Professor Harel for his comments here today. You're just have to unmute the Zoom.
Thank you very much for letting me join this project, which I found quite interesting and enlightening and also novel, I think, in some ways. I've written about Justice Barak, and basically, but I think that the lessons from Justice Barak's successes and failures are more general. And the task of a towering judge is first to accumulate the power to make changes, in the law and transform it in the way he regards as desirable. But the second challenge is to guarantee that his heritage will remain stable, namely that future judges will not use this greater power in order to dismantle the changes or the transformation that the judges made. So there are two tasks and there is a conflict between them. Because in order to be a towering judge, what you first need to do is to grant and have the power to make radical deviations from earlier decisions or transform the law in the way you think is desirable. But once this power is there, future judges can use it in order to, and politicians can use it in order to undermine your heritage. And I think that Justice Barak was brilliant in the first task, but it seems, at least at this time, that he failed in the second task. In other words, his heritage will be transformed, or is being transformed, and judges use powers that they have now in order to transform the heritage that he left. So many people have been talking, many theorists have been talking in recent years about the counter-revolution resulting from the rise of right-wing governments in Israel and the new judicial appointment of judges. As is well known, our former Minister of Justice, Ayelet Shaked, has appointed many judges, and her sole criterion in appointing judges was their political affiliations or inclinations. She used it in order to appoint many conservative judges. And under the conventional story told by some legal theories, the Barak instigated legal revolution has been to a large extent eroded and most likely is being overturned. I think this is a little bit misleading. And it's a little bit misleading because it doesn't distinguish between two legal revolutions in Israel. The first legal revolution I labeled in my contribution, the judiciary empowerment revolution or the institutional revolution. And the second is what I call the liberal or the substantive revolution. What I argued in the chapter is that while much of the criticism directed against Israeli legal revolution is directed against the judiciary empowerment revolution, the conservative forces in Israel have no urgent interest in overturning the judiciary empowerment revolution. As a matter of fact, they use the judiciary empowerment revolution in order to undo the liberal revolution and transform Israel into an illiberal democracy. In other words, a democracy that have regular fair elections, which does not respect human rights, does not respect freedom of speech, does not respect the right to equality, the independence of the judiciary, and so on. The judiciary empowerment revolution is simply an institutional revolution which has been designed to increase judicial power in various aspects of social and political life. This was done by Justice Barak in all fields of the law and by using many legal doctrines. It was done in contract law, in tort law, in property law, in administrative law, in constitutional law, in family law, and others. The most dramatic decision, of course, was Bank HaMizrahi, which authorized the court to strike down statutes on the basis of the basic laws. It has been used several times, but in addition, Justice Barak was quite brilliant in developing new doctrines in administrative law. For instance, the doctrine of reasonableness, under which decisions of administrative bodies have to be reasonable, and quite a lot of other doctrine. His basic idea was that we should not stick to the words of the law. We should look for the purposes, for the underlying intention, blah blah blah, and therefore use and therefore transform the law or evolve the law, develop the law in ways that are desirable. The liberal revolution injected liberal values into the decision making. The court used its increasing powers and willingness to intervene in order to promote liberal individualistic values. More particularly, it used its power to protect more vigorously human rights. It entrenched the values of dignity, autonomy, freedom in interpreting the law, and also advanced the values of equality and broadened the scope of some positive rights. I want to say that in this respect, many of my friends who are human rights activists in Israel say they are quite disappointed because there were some fronts in which the court was not able or was not willing to do much. The most important, of course, is the situation of the occupation and the human rights of Palestinians in the West Bank Gaza Strip and also Palestinians in Israel itself. But in many, many other areas, and even in this area, the court has done tremendous work. I want to emphasize that Chief Justice Barak believes that the two revolutions are interrelated. He believes that judicial powers are inherently conducive to liberal values. I think that his prediction was refuted by the fact. The main reason was the appointments promoted by Minister Shaked. Her interest was not to promote, interestingly enough, not to promote more differential judges. Much of the attack on Justice Barak in Israel, in the press, if you read the press or if you hear the news, and many of the critiques on Justice Barak is, why do you give judges so much power? Why is it the case that you give judges so much power? It's a democracy. We have to decide on our future. It violates the fundamental principle that the will of the people should govern, and so on, and not judges. But when you look at the judges that were promoted by Ayelet Shaked, by the Minister of Justice, you see they are not differential judges. In fact, they are activist judges, but their set of values, their substantive set of values is radically different, is illiberal. The conservative forces in Israel have been targeting for a long time the alleged activism or over-interventionism of the court. But I think that this accusation was used tactically to undermine the liberal revolution. The primary concern of the authoritarian political elites in Israel is not the two great powers of the court or the interventionist inclination, but its liberal values. As a matter of fact, the judiciary empowerment revolution instigated by Barak has become a tool to undermine the liberal revolution, which he also promoted. Consequently, although Chief Justice Barak may not favor this result, his judiciary empowerment revolution is here to stay, while his liberal revolution is currently being overturned by the judges. I think this is a more general lesson that I think not only judges, but also I think political leaders should learn. Once you transform the system, once you gain powers to transform the system and to change the course of, even I would say the course of history, in the case of Barak, it is very dramatic, the course of Israeli jurisprudence, and I think jurisprudence more broadly of constitutional courts. Once you gain the power, you open the door for future people to do it. The way political leaders prevent this or overcome this danger is by adopting a constitution. If you think about the revolutions, I don't know, Nehru in India or in many other countries, you make changes and then you stabilize it by having a constitution, and this constitution is there to stay. But judges cannot write constitutions, and therefore their achievements and successes are more vulnerable to changes in the future that ironically are facilitated by the fact that they open the door for judicial activism and judicial change and judicial innovation and so on and so on. Thank you very much.
Thank you so much, Professor Harel, for those fantastic reflections and insights. Allow me to let everyone know as well, Professor Dixon messaged to let us know she sends her apologies. She had to put her kids to bed. So she sends her apologies to her fellow co-panelists and the audience, of course. That's why she's no longer with us. Let me hand over the floor, however, to Professor Malagodi to share her the thoughts, insights, and the results of her research. Please, Professor Malagodi.
Thank you so much, Chris, for the kind introduction. Thank you so much, Rehan and Iddo, for the wonderful project and for including me. Thank you, Son, for organizing tonight's event. And I think my biggest thanks go to Kalyan Shrestha, who's put up with me in the course of over a year, over many, many conversations, cups of tea, and even dal bhat, for me to ask many questions about his work on the Supreme Court of Nepal between 2005 and 2016. I was looking back at my work for this project, and three main points kind of sticked out quite prominently. The first one is methodologically speaking, was the fact that I think my chapter, together with the Singapore chapter, were able to benefit from in-depth conversations with the towering judge that we've been exploring. And I was able to draw, in a way, a really full-body picture by having access to Kalyanji in person and being able to ask him questions that went beyond his judgment, that went beyond the 5-year plans of the Supreme Court, the media interviews, and all of that. And that, of course, was a wonderful opportunity for me as a scholar, but I think also in terms of the scholarship produced itself, it was really quite important to kind of see the man behind the bench, to see how elements of Kalyan Shrestha's life, upbringing, values, ideology came to play into the judgments and into his work, into the court, also in terms of priorities. And I think that's that kind of work shares a lot of assumptions of a lot of legal biography work, and it's the idea to bring to light those covert assumptions. So for that, I'm grateful. And in retrospect, I think it was one of the most interesting parts, I think, of my work on that. The second point that kind of stood out from rereading my chapter, looking at the blog post that we did, was the extraordinary amount of nautical metaphor that I ended up deploying in my work. And I think it's this idea of a storm. And if we look at the 11 years of Kalyan Shrestha's tenure on the Supreme Court, we're looking at an extraordinary moment of Nepali history. And that, I think, is one of the elements that I like the most about this project, which is the focus on the context, not just on the jurisdictional aspects of each of these judicial figures. And also the question of timing, when we ask the question, how do towering judges emerge, and so on. So all the nautical metaphors, aside from the maelstrom and the storminess of those years, also conversely led me to focus on what I call in the chapter the true north, the judicial true north that, in my view, Justice Shrestha adopted in those 11 years. And I think that's quite an important element, and it was quite a key tool for me to explore the work that he did. And I think there are a number of key values and key principles that I think contribute to the legacy and contribute to the towering nature of this judicial figure. And I think, you know, we'll start basically three main points here. In my view, Kalyan Shrestha saw the law as a protector of individuals, with special emphasis on the most marginalized. And that was an element that I was able to draw from conversations with Kalyanji about his upbringing, about his first experience actually working in more remote areas of Nepal as a development officer. So before he started a judicial career. The idea of poverty, the idea of development, the idea of marginalization, and how much that experience kind of shines through his judgments on the bench. Secondly, it was this idea of streamlining domestic Nepali law with international principles and international law. And I think, you know, one of the many chats, one of the sharp points that Kalyanji made was, well, domestic law should not be a stranger, should not be odd to an external observer. When you deviate so much from the norm domestically, then sometimes you really have a problem in your domestic legal system. And then the last of these three elements of what I've identified as his judicial true north is this focus on institution building. And I think that's where my third point in terms of legacy really comes out. So in terms of institution building, and I think that ties in with Ros's comments about leading judicial figures. And I think if you guys were to do a second project on leading judicial figures, then I think my chapter could, in a way, be reworked under that tag as well. And we're looking at the question of judicial independence. So that is something that, in my view, Kalyan Shrestha fought for tirelessly in a number of instances. First of all, in his judgments, in the way in which he decided politically extremely controversial cases, from dissolution of the First Constituent Assembly to questions of the forced retirement of a number of army generals. And then it's also the question of the capability and the capacity of the court as the legacy. So the idea of building something beyond his own tenure. And when we look at the legacy, of course, I think that's one of the disclaimers in my chapter, that because Kalyanji's tenure was so recent, it's a small claim that I make here. So alongside the institution capacity efforts as part of this judicial true north, I think what I see perhaps as a backlash is the fact that for being such a fearless judge, for a very clear take on judicial activism, a bold use of remedies, a bold use of precedent, a bold use of the doctrine, what you see is the fact that there were attempts throughout his tenure during the constitution building process between 2008 and 2015 to rein in the Supreme Court. And I think that's perhaps the other side of the coin, when you have such a fierce judge inspiring other judges in the higher judiciary to be quite so bold, that perhaps there is an attempt by the political branches of government to tame the judiciary. And I think that's what we see in terms of net results in the new constitution that Nepal promulgated in 2015. And I would like to close here my remarks. Thank you again for having me. I look forward to the conversation.
Thank you so much, Professor Malagodi, for those fantastic insights resonating with many of the themes that we've been discussing today. Let me turn over the floor now to another colleague, Professor Bui, for his insights and thoughts. Please.
Okay, thank you, Chris. Thank you, and congratulations, Iddo and Rehan, for the publication of the book, and thank you for including me on the book. My chapter is on Chief Judge Trương Hòa Bình in Vietnam, and so like Mara, I also have 3 things to say. This is the book launch, so I just want to make it more introductory rather than theoretical. So I have 3 questions. First, who is Trương Hòa Bình? Second, what make him become a towering judge? And finally, why? First question, who is Trương Hòa Bình? He was president of the People's Supreme Court in Vietnam for nearly a decade, from 2007 to 2016. Before becoming the president of the court, he was a policeman. He served as the leader in public security department. So he did not have experience in court. Another point about him is that he got basic education in water resource, not in law. It was reported that he got a master in law, but his basic education is not in law. Currently, he is the deputy prime minister. That is the background about my case. Second, what make him becoming a towering judge? He became a towering judge for 3 things. First, he support structural judicial reform. Under his leadership, the Supreme Court system in Vietnam was reconstructed. For example, the High Court was created to separate from the Supreme Court. So now we have 4-tier, 4-level court systems: the Supreme Court, the High Court, Provincial Court, and the District Court. Before that, we only have 3. The second structural development is he support the creation of 2 specific tribunals, the Family Tribunal and the Children Tribunals. The second, he also support functional judicial reforms. For example, under his leadership, the courts in Vietnam handle more than 4,000 corruption cases. It's very active in dealing with corruption cases. Another functional development is he supported the creation of the judicial precedent system, or the case law system in Vietnam. It's quite unique because under socialist law, we don't have case law in principle, but under his leadership, Vietnamese court can publish standard judicial cases, and all the Supreme Court can publish standard judicial cases, and all local courts have to apply as case law. They collect standards, good case, and pronounce as judicial precedents, and local courts have to follow. This is quite unique in the Vietnamese judicial reform. And the third aspect making him a towering judge is what we call position taking. He was very active in attending meetings, government meetings in the party, in the Communist Party, the parliament, the government, and also, of course, the judicial meetings in order to talk about the achievement in judicial reform. He also very active in publishing in popular newspaper or the party newspapers in order to advertise for new ideas or achievement in judicial reforms in Vietnam. So we call this the position-taking function. So with all of that developments, he became a towering. He was considered the hero of judicial reform in Vietnam. My last question is why? Why he can become a towering judge? The reason is institution. Nearly everyone, every judge, every president of the Supreme Court in Vietnam can become a towering judge because the law makes you become a towering judge. The Constitution and the law and the court system empower the president of the court, the chief judge. You have the chief judge is a very powerful position in Vietnam. So nearly everyone can become, if you have that position, you can become a towering judge. You have the structural power to create new courts. You have the functional power to manage the court system. You have the personal power to appoint local judges, and you also financial power to distribute financial among the judicial branches. So with that powers, everyone who take that position can become towering judge. The reason to centralize, the reason that they create a centralized position, a powerful position, is to make sure that local courts in Vietnam are under the control of the Supreme Court. That is the answer for the reason. So I don't want to go into more detail about this case, but I just again congratulate Iddo and Rehan for publication the book and add a very new area for developing comparative constitutional law studies. Thank you again.
Many thanks, Professor Bui, for those intriguing insights into a judicial figure who I dare say is one of the less known on the transnational stage, at least amongst the various judges considered in the work. So that brings our presentations today to a close. I note we have 10 minutes left. I suppose will use my authority as the chair to propose we stick around for a few minutes past the 6:30 deadline, just of course if those panelists are able to do so. If not, of course, we understand you doubtless have other engagements as well. But if those on the panel are able to stick around for a few extra minutes, it will give us a little bit of extra time for questions and answers. I have a couple questions already from the audience. Please feel free to send in more if you have something pressing you haven't sent in already. Before I turn to the questions, however, perhaps I'll open up the floor to our two co-editors in case they have any sort of concluding remarks, or if they want to reflect on, the various comments and insights ventured so far. Please, if you want to do so, the floor is yours. If you would rather get to the questions, let me know. It's as you will.
Maybe we can get to the questions.
Let's go to the questions. I agree.
Yeah.
Thank you.
And if we have time at the end, we can respond to some of them.
Okay, fantastic. So the first question is from Professor Swati Javeri, who asks, what are the generalizable conclusions the project seeks to reach? In investigating towering judges and their institutional setting, what general institutional conclusions or observations is the project seeking to make? Can the analysis of the judges selected bear the weight of these general conclusions, especially given the possible issues with the way in which authors selected their jurisdiction's towering judge, authors justified their choices, but another set of authors would equally well have been able to justify alternative choices.
I can start, if that's okay. So I think, thank you, Swati, for coming in for the question. I think we're hesitant to sort of say that we were seeking to make particular conclusions. I think, at least for me, what I like most about our volume is the richness of the individual case studies, and as Roz put it, the kind of granular detail that the authors bring to bear when talking about judicial leadership and the ways in which judges make constitutional change. I think there are a few kinds of trends that we saw, and some of these have already been mentioned. One is that collegial judicial leaders seem to do better in terms of a lasting impact on constitutional law than more individual leaders, right? And I think that's maybe for a couple of reasons. One is that by having a coalition or having a majority, they were able to actually change the law to a greater degree, right? And so Andrew talked about Anthony Mason. A similar dynamic happens around Earl Warren in the United States. Earl Warren was not necessarily the smartest judge, but he was very good at kind of bringing colleagues together. And so the Warren court, therefore, was very influential. By contrast, as Alon showed with Barack, though he was, a brilliant, towering figure, his legacy has actually been undone in many ways. Right? And we see that, I think, with some of the more individualistic judges. I think a second thing is what Iddo mentioned with global constitutionalism, right? And most of our judges coming up around the 1980s and 90s. And I'll leave it to you, Iddo, to say more about that. And perhaps the third thing we might say is, and I think I said this in the introduction, is that, being on the court for a long time and being able to write opinions seems to really matter, right? And so, if you're on a court where you're just kind of, joining unsigned opinions, or you're only on there for a couple of years, that's not conducive to becoming a towering figure. So those are just some general observations. But as I said, I think we're hesitant to say that we were seeking to make specific claims about the concept. It was more to interrogate the concept and figure out the different manifestations of it across these different systems and cultures. So Iddo, do you want to say something there?
I'll just say very briefly, thank you, Swati, for this. This is a really challenging question. And I think foremost, the conclusions are descriptive, I guess. I guess the title is one conclusion, right? That there is such a thing. And I think if we want to even emphasize it, I think we see here a new conception of what it is to be a judge. I think this is something new. So a great judge is not something new. A leading judge is not something new, but maybe a towering judge is, or at least the kind of revolutionary towering judge. I think descriptively, this is the way it manifested is interesting. So and then normatively, there's a very large room for debate here. Maybe I can touch about this a bit later. Yeah. Thank you.
Okay, fantastic. Let me just check if any of the other panelists would like to venture any insights at this point. Feel free to speak up. Otherwise, I will move to the next question. So we have another question from Roy Sturgeon. And he asks, why are judges from the late 20th and early 21st centuries included on the list of towering judges? Isn't it premature to know whether they will truly prove towering to later generations? So wouldn't it have been better to include, for example, pre-1900 towering judges?
I just can't resist saying a joke or kind of an anecdote. And I don't know if it's true or not, but I think there's an encounter with a Chinese politician, a European one, and the European one asked the Chinese, what do you think about the French Revolution? And he says, I think it's too early to know. Really, it's a perspective of time, and I think the question is in place in that we are specifically about judges that are even the most recent. We are still talking about things that are under development, but I guess as long as we're aware of that, we can say some things about them, right? And I think we also spotlight the fact that, you know, there may not be any point in time which is a conclusive point in time in saying someone is towering, because someone can be dethroned from being towering, right? There was a discussion about Justice Frankfurter in the US, and Mark Tushnet mentioned that he's kind of dethroning him. It was a mistake to think about him as a towering judge, although he was considered so for a couple of decades. So at any point in time, our perspective on these judges is also couched in our current agenda, current perspective, current whatever is going. And again, this is, maybe I'll just add another thing, that we have just a little bit of perspective coming from the fact that we are now after the height of global constitutionalism and at the time of change, right? So this may be a good time to pause and look at this. Again, we don't know how much, you know, how dramatic this change might be, how deep it is, but I think there's a consensus that the height has somewhat passed, and that we are now under a certain backlash, or at least a change. So that also may legitimize this timing. Thanks.
Fantastic, great. Any other thoughts or reflections on that sort of temporal issue? If not, I will perhaps, please, members of the audience, note the floor is still open. I will throw one question of my own into the mix as well, which is picking up on a theme I think Rehan mentioned in the introduction and Andrew picked up on in his contributions, which is sort of the tension around the hagiographic nature, you know, the sort of desire not for the project not to be that, but kind of the sort of potential that saying towering might start to slip in that direction. And my question in particular, you know, I guess my colleagues know my own work sort of started looking at the history of human rights and then turned to sort of looking at the history of human rights violations in a way. So my impression is most and perhaps all of the judges covered in this volume are ones that most of us would look towards with fairly sympathetically, you know, and generally put them in the, we consider these judges to have made generally positive contributions. But there are also doubtless a set of judges who most of us, again, would probably consider to have made contributions that we felt were less positive or productive, who might equally well, it seems to me, be described as towering, merely in a different sort of way. So I wonder, I would be interested in hearing a little bit more about that, about why, you know, sort of was the, am I right about this sort of positive inclination towards these judges? Was that actively produced? Is it just that those tend to be the judges who are more covered? Was there some, you know, what about the towering judges who perhaps have less positive impacts relative to rights and so forth?
It's a great question and a fair comment. So this is something we were concerned about. And I guess we should start by sort of pushing back a little bit on something Roz said, and you've sort of picked up on that, which is that we didn't actually choose the judges. That is, we looked for contributors, and for the most part, they chose the judges. And as long as those choices seemed plausible to us, we deferred to them as the experts on their own jurisdiction. But it is certainly true that people tended to choose judges who they sort of had a sort of normative attachment to, right? Thought they did good things. And we mentioned, for instance, somebody like a Justice Scalia, right, would be a good kind of counterexample, especially since, much of his renown is against the kind of globalist, rights protective jurisprudence of the sort that Barak or Bhagwati or some of these Warren or some of these judges were known for. So I think that's a fair comment. I think that's probably just a tendency of all of us, including the editors. I'm not sort of exempting us from this. But I do think that we are quite critical of some aspects of these judges, right? So I think my own chapter on Justice Bhagwati is very critical of him as someone who's, I think led the Indian judiciary in a non-ideal direction, perhaps unwittingly so, but some of the sort of, some of the rhetorical moves that he made and some of the institutional changes that he made were really not positive to the rule of law and the development of constitutionalism in India. And I think that's true of some of the other chapters as well, right? They're not sort of celebrating the judges as such. Some are more than others, perhaps for good reason. But it's more about, again, kind of trying to unpack the specific ways in which these judges were productive, right? Were able to sort of drive constitutional change. And then to assess, in some cases, and I think Alon's chapter does this really well, the degree to which they were successful, right? And so there's also a kind of critical aspect about sort of what happened afterwards, right? And so in Barak's case, especially, I think sort of what happened afterwards is a cautionary tale, right? And I think, as Alon put it, that's partly due to what Barak did. So I think there's sort of different layers of critique that I think are in the book, but it is a fair comment that I think most of the judges chosen, most of us feel somewhat positively inclined towards.
Mara, please. I see Mara putting her hand, so I'll wait. Yeah.
Thanks, Iddo. Excellent question. So when I look at my choice framed through the question that you ask about rights, I think for me, Towering was what he meant was an expansion of rights towards an expansion towards a greater protection of rights. So that was the way in which I've interpreted that. So Towering with respect to rights would be linked to that. And for instance, also in light of what Iddo was talking about in terms of global constitutionalism, I was looking for judgments that Kalyan Shrestha has authored that also have traveled beyond the bounds of Nepal, beyond the jurisdictional bounds, decisions which have been translated into English, which have been picked up by other jurisdictions, which have been cited, which have been recognized, for instance, of reproductive rights. So I would distinguish the toweringness with respect to rights, with respect to politically embattled cases. I don't know if that makes sense. So I think that for that, I have quite a clear criteria of toweringness with respect to rights. Thank you.
Can I jump in for, again, thank you for the question. And I'm repeating what Rehan said, that we were thinking about this. And I guess, first of all, we can distinguish between, I guess, what we might call villain judges, villain towering judges, so like really bad people, and conservative towering judges, which is the and probably there's in between, right? Or not so much villain, but just maybe unhelpful. But so true villains, I'm not sure would be their impact or the kind of impact they have might not put them in the same way in history as the way we're looking for, like a deep impact, not necessarily. So they might be acting under dictatorship, helping the dictatorship, or helping. So, but not necessarily we can't have them, but I think it's harder to think of them necessarily. But it is true that we don't have conservative towering judges, and we talk about this a little bit, but in saying that sometimes the conservative agenda is antithetical to toweringness generally, and to the particular toweringness of global constitutionalism in particular. They're not part of the gang. They're not either invited or want to be part of that group. But I want to take that opportunity to highlight some of the critical points that I at least see in that in some of the towering judges. And one point that I would like to highlight is that some of them acted in a way that they thought they could skip the political process or hasten it from above, and that was not necessarily possible, right? Or after the fact, we see the backlash, right? And I think that's definitely the case with Porat, knowing the details of it. So there was the idea that you can hasten history, skip the difficulties and the irregularities of the political process, the messy process, and do it in a neat way that will bring us to the end result quickly. And I'm not sure you can always do that. Sometimes you can do that with the help of the political process, but this is sometimes, or under some circumstances, harder to do. And I guess we also highlight some of the personal aspects. So it was being a part of that group for some of these judges was, was just fun and good, and that kind of enhanced maybe the wish to tower. But again, you can have just as many positive aspects as there are negative ones. And you're definitely right to say that the project itself lends itself to kind of valorizing idea, even if we don't intend to. Yeah.
Please, Andrew.
I see Andrew raising his hand.
Yeah, thank you. No, this is this feels like the workshop all over again. You can find someone asked the question, it just as a chain reaction. And this is kind of what I was trying to get at the end of my own presentation in terms of, the effusive praise that I feel our chapter is regarding Mason. And I think, Iddo, your comments earlier tonight around revolutionary judging sort of help explain this topic, because there's a difference between revolutionary and reactionary. And I'm not surprised that we don't see much of the latter in this collection, though I am really excited about a judicial villains book. I think that has real legs. But I do also think the timing aspect in terms of the rights explosion post-World War II and the sort of cosmopolitanism that we spoke of a lot at the workshop also explains why there's this thread through the judges. And even if the progressivism is flawed or meets with pushback, I understand, I think, why that has been so dominant a theme in our identification of the towering judges. But the question is a great one, Christopher, because it really, we were constantly testing each other throughout and with things like that. And, that's kind of, when I was jotting down remarks earlier, I thought, I need to talk about how we felt we were just, it was like a fan letter to Mason, and that wasn't what we were wanting to do, but why did we find ourselves writing that chapter?
Son, please.
Yeah, just on Chris' question, I chose the case mainly because it's the recent case. As I mentioned, every president of court in Vietnam can become towering judge. Regarding the first question, I think the important new point in this book is open an area for competitive constitutional actors. Our scholarships, we discussed, I think, 3 themes: ideas, institution, and dialogue. So now we have another topic to explore: competitively actors, personal actors. But what's next? 2 editors. Are you doing towering presidents or?
Villain judges for sure. We have Andrew suggesting.
Bestseller for sure.
You're all invited to villain judges next year.
Okay. So
I want to say, I just want to say again that this particular workshop reminded me how fun it was to be together and have these ideas. And I'm really proud of this project for having this intellectual engagement of us all. And I was very glad to be part of it. And thank you for allowing this get together to remind me of that.
So I'm very loath.
Sorry, Chris. Let me just agree with Iddo and thank the contributors who joined us. It's so great to see you, and I echo everything that's been said. Your chapters are why this volume works, right? It's the richness of the chapters that I'm most happy with. So thank you again, and yeah, hope to see the book in print later this week.
So I'm loath to cut this short. The conversation could clearly go on, but we've already run over our time. So many thanks to all of the panelists for their indulgence and staying over. And please, many thanks to you, the audience, for your participation. Please join with me in thanking and congratulating all of the panelists and especially the co-editors on this fantastic co-edited volume, Towering Judges. You can pick it up from Cambridge University Press and give it a read.